The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon, everybody. Welcome to the Fourth Circuit. We have 4 cases on the calendar for this afternoon. The first case up is Triplet v. Saul. And Mr. Farrell, whenever you're ready.
Thank you, Your Honor. My name is Clifford M. Farrell, representing appellant Kimberly Triplet. Wanted to start briefly by pointing out what this case is not about. This is a Social Security claim following the sequential evaluation that was denied at step 2 for lack of a severe medical impairment. It is not about whether the claimant meets or equals a listing or what her residual functional capacity might be or whether she can do her old work or any other kind of work. According to the Social Security's rulings, in particular ruling 8528, at the second step of the sequential evaluation, medical evidence alone is evaluated in order to assess the effects of the impairment or impairments on the ability to do basic work activities. It's a medical question. That's important because the judge, the administrative judge, and at points in time, the records have suggested that, well, and I think have suggested that perhaps she's not taking enough medication or not doing some of the things she should be doing. In fact,
Mr. Farrell, yes. This is Judge Thacker. What's your best evidence of severe impairment here?
The fibromyalgia is a by exclusion diagnosis. In this record, the treating physician, Dr. Gray, has indicated, actually there are 3 doctors that have all indicated it is severe. Dr. Gray, Dr. Sarusco, and Dr. Rutherford. The treating physician, Dr. Gray, his records document fibromyalgia, myofascial pain, and various impairments, which the judge conceded were medically determinable impairments. So there's no question she has the diagnoses. He just found that they weren't severe.
Well, Mr. Farrell, after the after the filing date for disability, what didn't Dr. Gray just primarily treat her for things like colds and other more minor things, not so much the fibromyalgia?
He did not, Your Honor. Dr. Gray referred Ms. Triplet out for various various workups on her medical problems. He referred her at record 399.
After the filing date for disability?
Yes, Your Honor.
What amount? All right, go ahead.
That's fine. He referred her out for a sleep apnea study at 399. That was because that is often associated with fibromyalgia. Orthopedics examined her, exhibit 590 or page 591, because they were looking for an orthopedic basis. There were other. He did refer her out for a common eye exam and for colonoscopy that are relevant here. But he did. Go ahead,
I don't know what to. What about the fact that as of July 10th, 2015, she was going to the gyms 3 times a week and doing strength training with weights and cycling? I don't do that.
That is exactly what part of the prescribed treatment is for fibromyalgia. You're supposed to exercise. You're supposed to do those things to try and minimize some of the symptomatology and to increase some of your strength. So
doesn't the fact that she's able to do those things 3 times a week, isn't that some indication that she may not be severely impaired to the point of being disabled?
It may come in an evaluation of residual functional capacity later on, but at this step, as to whether her impairments are so baseless as to not warrant any evaluation of the claim, I don't believe that factors in here.
I thought the test was whether or not the impairment significantly limits his or her physical or mental ability to do basic work activities. And why wouldn't the ability to do what Judge Stacker just described be relevant on that point?
Because at this point in the process, in the sequential evaluation, it is a medical determination. Things that go to the RFC, and those would clearly go to RFC. Can she do sedentary work? Can she do her past work, other work? Those are clearly relevant. But as the commissioner's rulings point out, it is strictly a medical determination. And it wasn't, I want to point out, it was not just Dr. Gray that said these are severe medical conditions. Both the state agency doctors at record 98 and record 109, both Dr. Sarusco and Dr. Rutherford specifically indicated that I think their problem was they couldn't decide if it was fibromyalgia or what it was. Whatever it was, they both indicated that it was severe. Page 90.
Can I ask you a question?
Yes.
I'm sorry. I didn't mean to cut you off, but I think the state's doctors both said it was severe. Are there other cases? I mean, is this happening frequently? Is this the first time you've seen this where fibromyalgia is deemed not severe at step 2? Is this unusual, or I just don't have a feel for this?
I would not say it's unusual. I would not say it's frequent either. And I know that's not very helpful, but I have seen cases in that, and I think we cited one case from the Seventh Circuit, Sarche v. Chatter. I have had probably half a dozen times in my career where an impairment was found not severe, some of which have been reversed by appellate courts, and I think they've all been. I mean,
but fibromyalgia, I'm sorry, my question, fibromyalgia was deemed not severe at step 2? I know sometimes ailments are deemed not severe, but I was just wondering.
Fibromyalgia, I have rarely seen, and that's because there is no test that can confirm its presence yet. And so rather than err that way, most judges say, I'm going to find it severe, and then they evaluate residual functional capacity and whether they can do other work.
But isn't that what happened, Mr. Farrell? Isn't that what happened in this case? Didn't the judge ultimately get to the residual functional capacity and make a finding that she could do the work that she had done previously with some limitations?
He did not, Your Honor. He does mention in what I consider sort of a dicta opinion near the end of his decision that she could possibly go back to her past work. The sequential evaluation is a very procedural process, and at no point here did he evaluate whether she met or equaled the listings. And we're not.
Well, I guess he must have assumed that in order to get to the step 4 evaluation with respect to residual functional capacity. Now, it may be that the argument is that his opinion, or her opinion, I think it was a woman ALJ, was colored by the fact that she didn't perceive the impairment to be severe. Maybe that's the response, but didn't she get to the issue of whether or not she could do work with certain limitations?
She mentioned, or in the last paragraph, one of the last paragraphs of her decision, she does discuss that. But the problem is the rulings and regulations are very clear. Before you get to step 5, you have to go through step 4. And before you get to 4, you have to go through 3. You can't go from it's not a severe impairment to plus she can work. It defeats the whole purpose. I mean, that's why they set up the sequential evaluation, so all claims are evaluated the same way, so the claimant always understands what's going on.
So in your mind, the ALJ, if she felt confident enough about the step 2 analysis, should have just stopped right there and done nothing more?
That's what the rulings say. I think 8528 specifically says you go through the steps in order, and at any point you stop. Now, there are occasions where that might be appropriate. If somebody at step 5 says, well, maybe they can do some of their old work, but I'm going to go ahead and discuss these other jobs. I certainly understand that. But to go from not severe, meaning de minimis, no significant limitations, to she can do her past work with nothing, no discussion of the other steps in between, is just not the way the analysis goes, especially when the state agency doctors agreed with the treating doctor that she's significantly.
Do you think that, and I agree with you, that it appears that the ALJ made a mistake with respect to the opinions of the state doctors, but let's assume that she had accepted all of those opinions as fact, that they had all come to a conclusion that in their minds that this was a severe impairment. But the ALJ could have, I suppose, nonetheless discounted those opinions in light of the record evidence that suggested that she could do a lot of the things that would appear to be inconsistent with a finding of a severe impairment, like going to the gym, like going to amusement parks. I think she went to Disney World and did some other things. The ALJ could have done that, right?
The judge could have considered those. I think, quite honestly, that there had to be a step 2 denial, because if you look at the medical opinions of the various doctors at any other step, at step 4 or step 5, it would have been approved. The only way to really deny benefits for somebody of her age is to say her impairments aren't severe. Because if it's not the ability to do something on a short 5-minute, 1 day, 1 week basis, it is the ability to do them on a sustained 8 hour per day, 5 day per week basis. And that's where the judge was having problems, because the treating physician was saying she's going to have days where she's going to miss work because of her problems. And the consultants were saying she's going to have problems making it through, certainly can't do more than 6 minutes, 6 hours of sitting and 2 hours of standing and walking. So there were significant limitations. And at her age, and depending on what the judge then, when properly evaluating the evidence, I think this judge would have been likely to have approved this claim. In looking through, Dr. Gray as I pointed out, has been seeing her since 2013. He's not the only doctor to have diagnosed the fibromyalgia, though. The orthopedic doctor who examined her for her coccyx specifically made a diagnosis of fibromyalgia as well, 691. The rheumatologist was ruling out some of the more rheumatological disorders, and also said, it looks to me like fibromyalgia is high on the list. That's at 407. Then they have the MRIs, and he sends her out for these different tests. And so ultimately, by the time he fills out the assessment in 2017, he's now gone through the sleep apnea. He's gone through all of the other studies and reached the point where he can say, this is what's going on. And it's for those reasons. She tried the physical therapy. That didn't work. She had the top tests to rule out other diagnoses, and she had injections. She tried different medications. In short, she did everything I think she could have done. And I think that if this was truly a non-severe impairment, I don't think we would see a record of this much referrals out for consultative examinations and specialist evaluations, and the consistency of her complaints of pain. Do they fluctuate? Absolutely. Does that mean it's not severe? Absolutely not. I don't reserve the rest of my time unless there's another question.
Thank you, Mr. Farrell. Mr. Lucier, we'll hear from you.
Good afternoon, Your Honors. My name is John Lucier from the U.S. Attorney's Office in Richmond, and I represent the appellee, the Commissioner of Social Security. Under this court's precedents at step 2 or otherwise, if a symptom can be reasonably controlled by medication or treatment, it's not disabling. And that's what the ALJ found here, and properly made that factual finding supported by substantial evidence that Ms. Triplett's symptoms of her fibromyalgia, pain, and chronic fatigue were reasonably controlled by medication or treatment. And that's supported by the record. Her primary care physician, Dr. Gray, after she had complained of pain, referred Ms. Triplett to a specialist, referred her in March. Ms. Triplett saw that specialist, a rheumatologist, beginning in June of 2014. Went back in July of 2014. In July, the rheumatologist diagnosed fibromyalgia and prescribed a medication for it, Ultracet or Tramadol. She returned to the rheumatologist in September of 2014, and the record for that visit states that by report that Ms. Triplett had good tolerance of treatment and good symptom control. She didn't go back to the rheumatologist for a year, roughly, until July of 2015. In July of 2015, The record states that she had tried the medication Ultraset and that it helped and that she would continue to use it. And as Judge Thacker pointed out, in both September of 2014 and July of 2015, she also reported exercising 2 or 3 times a week during those visits.
Mr. Lucier, your colleague on the other side, excuse me, Judge Diaz here, ended his argument with a summary of Dr. Gray's opinions that the claimant in this case would necessarily have a number of, the way he said it, a number of bad days that would prevent her from being able to work and would necessitate bed rest and the like. Did you recall hearing that summary?
I do recall.
So what about that? I mean, what are we supposed to do with that?
Well, the ALJ discounted Dr. Gray's opinion, and that opinion is a November 2017 fibromyalgia questionnaire where Dr. Gray went down and checked certain items on that list.
Just to be clear, Mr. Lucier, this is the treating physician, right? So aren't we supposed to give some extra level of credence to that opinion?
Well, the ALJ, the treating physician rule applies unless the ALJ finds, and of course the finding has to be supported by substantial evidence, that the opinion of the treating physician is contradicted, is inconsistent with other record evidence. And we have that here. The ALJ properly made that finding here, supported by substantial evidence, because as Judge Thacker pointed out, towards the 2017 period, after Ms. Triplett stopped seeing the rheumatologist, and the last time that she did was in August of 2015. After that, Dr. Gray saw Ms. Triplett for things like a cold, hypertension. Ms. Triplett had a fall where she injured herself and was being treated for pain from that fall. After the August 2015 ceasing of the rheumatologist visits, there are no complaints with respect to fibromyalgia after that point. And at that 2015, the last visit with the rheumatologist, Ms. Triplett, by self-report, was feeling better and rested better and responded well to the medication that she was on. So the opinion of Dr. Gray, yes, it's a treating physician opinion, but there is other record evidence that the ALJ found contradicted that with respect to symptoms of fibromyalgia. And specifically that at that point, by November of 2017, when Dr. Gray rendered that opinion, she hadn't seen a rheumatologist at that point for over a year. And the last time she saw a rheumatologist, which of course was specific to treating the fibromyalgia, she reported that she had improved symptoms at that point. And so I think that the ALJ, viewing the record as a whole, yes, the ALJ did discount the 2017 opinion of Dr. Gray, but that's supported by substantial evidence. The ALJ's decision to do so, that is supported by substantial evidence.
What about the fact that the ALJ just simply got the opinions of the state physicians wrong? I mean, just as a matter of fact.
Well, Judge Diaz, I think your question to Mr. Farrell pointed out, well, there are two answers. One of which is, as you pointed out, Your Honor, the ALJ made the additional finding that even if the ALJ had accepted those opinions of severity, the ALJ would have nonetheless found and did nonetheless find that Ms. Triplett was not disabled because she could, even at a sedentary level, the lowest level of work exertion, she could return to her past work as a vocational rehabilitation counselor at that sedentary level, because that's how it's done generally in the national economy. So it's even if the ALJ were incorrect in that factual finding as you described it, nonetheless, the ALJ would have accepted it and found her non-disabled. And the other reason is because the ALJ didn't discount the opinions of the state agency physicians sort of in a vacuum. The ALJ did so while looking at the whole record, and for the same reasons that I just said, which is that her course of treatment showed consistent improvement from the time she started seeing a rheumatologist to the time that she stopped, and she had stopped.
So I will tell you, one of my many concerns about this case is that, as your colleague was saying, at step 2, this is a medical assessment, and there are 3 doctors, only 3 doctors, but 3 doctors in agreement that this is severe, that this meets the step 2 medical criteria. The ALJ misunderstood that. The ALJ thought that the doctors were split 2-1 and that she was agreeing with two of them that it was non-severe over the objections of the treating physician, which is a more kind of standard setup. So I can see, that probably seems sort of familiar. But that's a colossal error to make. And I am left without much confidence that it would not have infected the rest of the way the ALJ was looking at this record, that she misunderstood that there was actually unanimous medical testimony on the medical question of whether her impairment is severe, and the ALJ didn't understand that. I don't understand how we can be confident that that error doesn't affect the rest of the analysis.
Judge Harris, I take your point. I disagree that it's a colossal mistake in this respect, which is that the ALJ, yes, made an error in saying that the state agency physicians found non-severe, but the ALJ then went the next step and said, listen, even if I agreed with that and found the impairment to be severe, I nonetheless would find that Ms. Triplett was not disabled. So.
Right, but my concern is that that wouldn't, the treating physician doesn't agree that she can do this work at the sedentary accommodations are made. And so my concern is that her misunderstanding of how the doctors aligned on this question would have affected her decision to discount the treating physician's opinion. I just don't see how we can separate them out so cleanly.
Your Honor, I think that on this record, combined with the ALJ's decision, you can get some comfort that it didn't infect the rest of the ALJ's decision, because the ALJ went through the entire longitudinal record from the beginning of complaints of pain from fibromyalgia to the end of those complaints and reviewed all of that medical evidence.
Well, we don't have to get into everything, but I did have some concerns about the ALJ's analysis of the longitudinal record, and I would have expected that for an ALJ finding that a condition is well controlled with medication, there would have been some discussion of all the side effects from the medication and the degree to which those side effects sort of impaired her ability to use the medications to control her symptoms, to the point where she ended up in the hospital with side effects from the medication, and the ALJ doesn't mention any of that. So I actually was not as reassured by the ALJ's assessment.
Well, Your Honor, there's a recorded in the medical record side effects for one of the medications, Celebrex. Ms. Triplett testified at the hearing, which was in December of 2017, I believe, that she had experienced side effects from tramadol, which was the medication that she was on. However, she was on tramadol for more than a year, and there's no record of any allergic reaction to it within that year. And in fact, as I said earlier, she was feeling better from using it and showed some positive influence on her symptoms. So there is a recorded instance of a reaction to one of the medications, but the record doesn't show a recorded instance of a reaction to the medication that she was on, which is tramadol Ultracet.
Okay.
At step 2 and otherwise, under this court's precedence in the Gross v. Heckler case, if a symptom can be reasonably controlled by medication, it's not disabling. The ALJ here made that factual finding, and the finding was supported by substantial evidence. Thank you, Your Honors. If there are no more questions.
Oh, I do have just one quick question. So the ALJ relied on some other things too, which we have, and the ALJ didn't have the benefit of our decision in Arrakis, but we later clarified that you can't rely on things like a normal range of motion, like the fact that the treatment was sort of routine kind of conservative treatment. All of that is stuff you're not supposed to look at all. I'm assuming your response to that would be, well, it doesn't matter. Like, we can take that stuff out. You just, kind of harmless error. She shouldn't have looked at that. She did, but there's no reason to think it affected. There's no reason to think any of these mistakes affected her analysis, her end analysis.
Yes, Your Honor, I agree, but I would also add that I think that Arrakis shows what kind of case this is not. And so I don't read Arrakis as saying that an ALJ, for example, can never look at the type of treatment a claimant receives. I just think that Arrakis says if the ALJ does so, the ALJ has to make a finding that's supported by substantial evidence. And so in the Arrakis case, the claimant was not receiving, the court found, the claimant was not receiving routine treatment. She had seen a rheumatologist for 20 years, had tried various types of medications, had been referred to different specialists, had received injections, and so on and so forth. And in this case, we have something that's fundamentally different. Ms. Triplett was referred to a specialist, was treated by that specialist, reported symptom control, and then stopped seeing that specialist. And after that, only saw her primary care physician for routine matters. So I think that in this case, it's just a different case than Arrakis was.
Just to follow up on that, so, and Judge Harris talked earlier with your colleague about fibromyalgia, and I'll confess that I'm not an expert with respect to that. I know that it afflicts a great number of people, and it's unique in the sense that there's no tests for it. It's largely subjective. But that's sort of a bit of a conundrum, right, when it comes to disability claims, because if it is subjective, then in some cases, that subjective analysis or evaluation of pain may be less than truthful or less than full and fulsome. And so it would seem to me logical that you would have to consider other objective evidence that is both consistent with and contradicts the diagnosis. And so I don't read Arrakis, and I think you've made this point as suggesting that the ALJ is forever barred from considering that kind of evidence in the face of a claim by a claimant that he or she is feeling subjective pain, right? You accept that, obviously, but then you look to the record and see if, in fact, that subjective pain is consistent with the daily activities and all the other stuff that appears to be in this record. I mean, is that fair?
Yes, Your Honor, I think that is fair. I think that Arrakis says that there's a particular, the ALJ errs in requiring objective medical evidence that confirms a diagnosis of fibromyalgia, but that's not what happened here. The ALJ here said, yes, she does have fibromyalgia. It's the next step are the symptoms from that diagnosis, are they controlled by medication and treatment? And in making that finding, part of what the ALJ relied on was Ms. Triplett's subjective reports to her doctor that she was feeling better after she started taking the medication when she was referred to the rheumatologist.
Okay. My colleagues have any other questions?
I don't.
Thank you. Thank you, Mr. Lucier.
Thank you.
Mr. Farrell, you've got some time for rebuttal. Go ahead.
Thank you. The fact that Ms. Triplett was responding to not working and taking medication, I think helps support her claim. And it draws me back to the part of the judge's decision where he gave the state agency opinions little weight. It was determined that the claimant did not have a severe impairment, but then she was reduced to sedentary exertion. And that was the part that he found that was inconsistent. This level of limitation is not supported. The evidence shows she has only received routine treatment, not required specialized treatment, rehab, or extensive follow-up. In fact, the record shows just the opposite, that in fact, she was getting all the appropriate treatment, all managed through her treating physician. It is a subjective impairment, and I would simply point out that not only did both doctors for the state say it was a severe impairment, they both noted that can one or more of the individual's medically determinable impairments, which includes her fibromyalgia, be expected to produce the individual's pain and symptoms? That's at record 98 and at record 109. And answered by the doctor was yes. And then the next question, are the individual statements about the intensity, persistence, and functionally limiting effects of the symptoms substantiated by the objective medical evidence? Both state agency physicians answered yes. Her symptoms are real, they're consistent with the diagnosis, and they're substantiated. Now we have three doctors, all three doctors concur that those symptoms are substantiated by the objective medical evidence alone. And that's the last word in the question, alone. Based on the medical evidence, And it is difficult, and I spent a lot of time in preparation for this, trying to distinguish between what does the medical evidence say and what is RFC related issues, and it is difficult. But in this case, to say that there is no severe medical impairment is simply not supported by the evidentiary record. All three physicians agree it is. The symptoms are consistent. The symptoms are supportive of the diagnosis, and that her complaints are consistent with the record.
Mr. Farrell, can I ask a question? You made an argument. You said something in your opening about it appears that had the ALJ actually gotten past step 2, that she would have necessarily found that she was disabled. And I'm not sure I understood why you think that's the case, why that can be the only conclusion based on this record. So maybe you can explain that to me.
Sure. I believe that because the nature of the diagnoses in the record and the references to the doctors of problems with fatigue, the dizziness, which are all parts of fibromyalgia, the absences from work, I think that those things all combine to leave an administrative law judge in a difficult position. For example, if she has dizziness, that impairs her ability to walk. If she is going to miss 3 days a month or more, or even just 2 days a month, that is inconsistent with competitive work activity, because you can't be absent 24 days a year from a competitive work environment.
Okay. All right. Thank you very much. The case is submitted. We very much appreciate your arguments, and regret that we could not be live in Richmond, but nonetheless, thank you for your arguments. And we would normally step down from the bench. Obviously, we can't do that to shake your hands, but know that we are grateful to you both for your presentations here this afternoon, and pray that you will be safe and well. So thank you again.
Thank you. Same to you, Judge.
We will be prepared to move on to our second case, Connor versus Covale Corporation. There we go. All right. Ms. Shirley, whenever you're ready.
Shirley.
Ms. Shirley, we can barely hear you.
Better?
Yeah, you might need to either put the volume up or move closer to the microphone. I'm not sure what's going on.
Better?
It's
Not good.
it's
Yeah.
sounding kind of muffled, Miss Shirley.
Can you?
A little bit. Yes, go ahead.
Okay, I apologize for that. I tested it out.
I think it'll be okay. Just and go ahead. We'll let you know if it's not working.
Okay, I appreciate that, Your Honor. Well, so I represent Daryl Connor. He's brought wrongful death claims for the death of his father, Connor, from the coma. We're asking the court to reverse summary judgment of the corporation.
Yeah, this is not
this
is not working. Yeah, maybe we can disconnect you and bring you back on. Can you, Anisha? Can you do that, or see what we can do?
Yeah, we'll pause the time and start it over.
Okay, thank you.
Hang on 1 second.
apologize. I apologize about that.
Uh-oh.
No.
Let me hear your voice again. Go ahead.
Can you hear me? My name is Lisa Shirley.
We can hear you when you move closer to the screen, but the minute you start stepping away, it becomes a problem.
Okay. Let me see if I can. Is this better?
Yes.
Okay. So I'm not sure what you heard before, but what we're asking the court to do in this case is to reverse the summary judgment that was granted to Coble Corporation. Are you able to hear me all right? Thank you. District court improperly weighed the evidence in the case and also drew inferences not in our favor, but in favor of Coble Corporation, which was the moving party. The court also failed to consider evidence regarding asbestos exposure levels and our expert causation evidence. I think it's helpful to divide the evidence into three general categories for this discussion. The first category is our fact witness testimony regarding Connor, the job that he did in fiber industry, and the way he was exposed to asbestos from Coble supplied insulation. And that testimony included what his job was, included testimony from insulators, testimony how close he was, how he interacted on almost a daily basis with those insulators.
Actually, I don't recall actual testimony. This is Judge Thacker. I don't recall testimony saying that he interacted on a daily basis with insulators, and even when he did step out of Building P, where he did most of his work, I don't recall him seeing insulators on a regular basis or stopping to interact with them on a regular and frequent basis. What is your best evidence of that in the record?
Yes. So one of his own testimony was that he saw the Daniel workers several times a day. We also had several types of interactions.
But seeing the Daniel workers when they were working on insulation and stopping and being exposed to that are two different things, aren't they?
Yes. So what I was going to say was that he had multiple reasons to be interacting with Daniel insulators. He had testified that if the Daniel insulators were doing something that would impact the trainers that he supervised, he would intervene. He also said that sometimes when certain repair work was needed that Daniel was going to be doing, that he had to be giving permissions for that repair work. And that would involve some back and forth with the insulators. He also testified about having to actually show the Daniel workers how to do certain kinds of repairs on an equipment called the Krell. In addition to that, he was friends with the Daniel insulators. His coworker, Troy Witherspoon, testified that they would stop and talk because they had become friendly because they worked together. Witherspoon obviously worked with Connor they saw each other on a daily basis. They were both in the training department. And he verified what Connor said about how he would be out in the main production department every day. Witherspoon was certain that Connor would have been within 2 feet of Daniel insulators 1 to 3 times per week. And this was not just because they had similar jobs in the training department. He said that this was because he personally observed Connor in the main production area and also personally observed the Daniel insulator. So in terms of in terms of the Lorman test, so obviously the court knows that's the frequency, regularity, proximity test that's going to be applied for causation in this case. All of those things that were regular parts of his job that brought him into close contact with Daniel workers, that satisfies frequency and regularity factors from Mormon. The duration of this was 16 years. He was at Fiber Industries. Mr. Connor was at Fiber Industries from 1966 to 1982. Proximity, as I mentioned, he was within talking distance with the Daniel insulators many times, sometimes multiple times a day. That was within 2 feet, according to his coworker. And we also had testimony about what those insulators were doing when he was there. The Witherspoon testified that the Daniel workers were primarily doing insulation work. That it would be dusty, that they would be doing it right there in front of everybody. The Daniel insulators, we had 3 Daniel
Miss Shirley, when asked, Mr. Connor, when he was asked at his I think it was at his deposition about where it would have been, he would have been exposed to asbestos during his work life, he didn't mention Koval, did he? He mentioned doing railroad, or the time he worked for the railroad as a machinist mechanic, working on the steam engines. He didn't mention Koval. Correct?
Well,
so what are we to do with that?
Well, I think that was his initial reaction. That was his memory. He was 90 years old when he gave his testimony.
Because he worked much longer at the railroad. Well, not much longer, but longer. He worked a long time, 19 years maybe, at the railroad, with direct hands-on experience as a machinist mechanic on the steam engines and boilers, directly working with asbestos, as compared to working in the training department and building P that he described as clean as your own home in Koval. What do we do with those 2 competing work environments?
Okay, well, first of all, he did have more, I would say, intense exposure at Southern Railroad. He didn't really work there longer, and he didn't work around asbestos insulation longer. It was about a 7-year period that he worked around insulation when they used steam locomotives. So this is in the late 40s and the early 50s. And he said when they changed over to diesel, they didn't use asbestos insulation anymore. But it was a more intense, frequent exposure at concentration. But what that doesn't mean that he didn't also have actually very high exposures at fiber industry. This is the same type of product. Asbestos insulation causes extremely high exposure levels, even to bystanders, even to people that weren't working with the product. He wasn't working with it at Southern Railroad either. He was a bystander to the insulation there as well. And at fiber.
Ms. Shirley, do we know where in the facility this particular asbestos was actually installed and or stored?
Well, the testimony was that it was all over the plant. It was on every high temperature pipe. There are miles and miles of pipes to the plant. Most of the insulation used in the plant was asbestos. That was the evidence that we had. And Daniel, that's what they did. So if you're talking to Daniel workers, it's going to be next to asbestos insulation. In terms of where it was stored, there was testimony that they stored it basically in an open area in the plant, and they would sometimes cut it out in the plant in front of their workers. The Daniel insulator said that they would be cutting and installing insulation within 3 or 4 feet of the workers. They didn't really cordon off the area normally. They didn't use any precautions to keep down the dust. They even said, a couple of them said that the dust would be visibly drifting out into the plant. We're not really saying, a couple has sort of suggested, well, he was just walking through the plant and that was exposure. That's not really what the evidence is. It's that he was coming up within a few feet of them several times a day due to various interactions that he had to do. And so he was directly exposed during those interactions within several times a day.
Counsel, sorry, it's Judge Harris. Can I ask you a question? So as I understand, I mean, a big part of your argument is that the district court wasn't looking at the record in the light most favorable to the plaintiff. But if one did, you think we would get to Mr. Connor being on the plant floor regularly within feet of the Daniel insulation workers? There's at least some interaction a couple of times a week. Is it your position that that's enough to satisfy Lorman, regardless of whether we take account of the specific disease at issue? Or is it that that's enough if we also take account of the fact that this is mesothelioma, so that you don't have to be quite as close and it's in the air and you are more easily exposed to it? Do we have to take account of that also, or do you think this goes to a jury even if we don't?
I think it goes to a jury even if we don't. But I also think that it's a consideration that should be a factor in. But we do think it should go to the jury even if we don't. And we're obviously not testing the Lorman and the Lorman factors apply.
Ms. Shirley, can you get a little closer to your mic? Yeah, go ahead.
We're not disagreeing that Lorman applies in the case or anything like that. But this is actually quite comparable to several other cases from this court that have relied on coworker testimony, circumstantial evidence, and held that was sufficient under Lorman. And I would just quickly direct the court to the Rolling case, 786 F. 2nd 1225. Also the Hayslip versus Owens Corning fiberglass case, 86 F. 3rd 1150. That case is a really interesting one because the plaintiff, that went to a jury and it had a plaintiff's verdict. It was an appeal from a plaintiff's verdict. And there, the plaintiff, who had, eventually passed away, he had denied that he had exposure to Kalo asbestos pipe insulation. But his coworker said, no, we did. For 9 months, we worked around insulators and they were constantly cutting and installing Kalo right around us. And the defendant had appealed that, saying, well, this guy isn't credible because he was friends with the plaintiff and because he had been shown a photograph of Kalo. He didn't remember it until he'd been shown a photograph of Kalo. In Hayslip, the court said, no, that evidence was sufficient to reach a jury and to create an issue of fact because it's for the jury to be assessing the credibility of witnesses. So that is another case, I think, in line with the type of evidence that we have here. Also, Shetterly versus...
But when you're saying it's in line with the type of evidence we have here, you're saying it's because it's coworker evidence, because correct? Because not necessarily the same type of duration and frequency, because even when you just described that case, it was 9 months of frequent contact with insulators. That's not the same sort of contact by either duration or frequency that we have here. Might be coworker testimony, but the frequency and duration is not the same. Would you agree with that?
I do agree, but we had a longer duration here. We had 16 years of daily interactions.
Did you say daily interactions?
Yes, Your Honor. I mean, the testimony, even that the district court had relied on, said that he saw them several times a day. And like I said, the fleshed out testimony was that included talking to them. But I did want to address the issue.
Did it include talking to them while they were installing asbestos?
Well, I think that's an inference that has to be drawn.
Okay, well, that's a big inference.
Well, I mean, that's what they were doing. And they said that they were doing that around other workers. We also had evidence in the records the trial court didn't consider about these asbestos exposure levels that you would have. They're extremely high exposure levels, even for people who are standing next to the people while they're at work. The fibers remain suspended in the air. So if they stop fibers, scientific evidence was we had a study at 1904. In the record.
You can answer this question, or if it's really for you, but I just didn't understand quite what was going on when the district court said that the Daubert challenge to your expert witness was moot. Because I think you actually started out trying to explain the different buckets of evidence you had, and it seemed to me that what the district court said was that your fact witness testimony wasn't enough to generate a material issue of fact as to causation for the jury. So therefore, she didn't have to consider whether you're expert at. Why was the Daubert challenge moot?
Well, her reasoning was exactly what you just said. Because we had not shown exposure, or she didn't consider any of the evidence that had been included in our expert report. He has like a 30-page expert report that has all this information in it about exposure levels that were never inviting the risk to bystanders, et cetera, that were never, it was never contradicted by Coble, never challenged in a kind of Daubert way by Coble. She just didn't consider that. And then also my three categories were, the fact witness testimony, that scientific evidence, the exposure levels and fiber drift and the risk to bystanders. And then my third category, which was neither one of those was challenged, in any kind of admissibility way. But the third category, there was a Daubert move. And our position is that if she wasn't going to agree with our other two categories of evidence, she should have reached that expert issue and considered.
Thank you, Ms. Shirley. Mr. Lynn, we'll hear from you.
Thank you, Your Honor. Good afternoon, and may it please the fact that there are actually two different questions in this case, and Judge Harris, I think it answers in part what you were asking about in terms of the Daubert challenge. There's two different questions, and I think the first, if you answer it the way that we think it should be answered, moots that question. The threshold question here in this case is about actual exposure. And I think the second question is, if you find that there is enough evidence to go to the jury on actual exposure, then there's a question of quantity of exposure and how much evidence is required to get to the jury on the quantity issue. And the expert testimony, Judge Harris, I think goes to the quantity question. So on the threshold question of actual exposure, again, I think that the question there is there evidence in the record from which a jury could reasonably conclude that Mr. Connor was exposed at all to asbestos dust at the fiber industries plant? And I think both parties agree that that's not really a Lorman, it is in part a Lorman question, but it's not about frequency, regularity, and proximity. It's governed because there's no evidence here of anybody having seen Mr. Connor being exposed to asbestos dust. Mr. Connor himself says, and Judge Thacker, as you pointed out, the plaintiffs say, well, he's 90 years old, but he remembered in vivid detail the 20 years that he spent at the railroad being covered in asbestos dust and the type of work he was doing, having it all over his clothes, coming home, and how he had to remove it from his clothes. He doesn't testify to being exposed to asbestos dust. He doesn't even mention asbestos dust at the fiber industries plant. And so under the rolling question, there's two parts to it. You need evidence to show that there's airborne asbestos such that he breathed that dust. That's what rolling says. And I think what you heard from Ms. Shirley today and what we see in their briefs is that turns critically on this 2 feet testimony from Mr. Witherspoon. They mentioned it 7 times in their briefs. She mentioned it a number of times today because there's no other testimony that even purports to put Mr. Connor near enough to the Daniel installers that he would have been inhaling this asbestos dust. It really turns
the Lorman question. You're saying, because I couldn't find really, like Lorman doesn't talk about this as a 2-step inquiry. Most of our cases certainly don't. Why? So you want us to consider proximity, but consider it not under Lorman, under some separate test? A pre-Lorman test. Is that what you're talking about?
Yes, Your Honor, and because I think Rolling talks about that, which was issued at the same time as Lorman, and it doesn't even get into the frequency, regularity. And it was issued
just the proximity, but you want us to talk about proximity.
Yes, it was issued that same year as Lorman. Actually came out afterwards, and it talks about how there needs.
How is this help?
I'm sorry, Your Honor.
I'm sorry. Go ahead.
That Rolling talks about how there has to be proof that he was close enough within the vicinity that he breathed that dust such that there was even exposure at all. Because if there's no evidence that on which the jury could conclude that there's even exposure at all, there's no question that needs to be raised about how much.
Okay, Mr. Lynn, but what if we do think that Lorman applies and we do look to Lorman, then what is your argument?
Well, Your Honor, it's twofold. I think the first problem they have is I think we still come back to the Witherspoon testimony. Because the Witherspoon testimony is what the only thing that they have that puts him within a certain vicinity, a certain proximity, and within any stated regularity. They say 1. And I think the problem with the Witherspoon testimony is that it is, as the district court concluded, it's just a guess. It's Mr. Witherspoon's belief as to what Mr. Connor was doing and how he did his job.
Can I ask you something? Can I ask you something? Just assume for a minute that I'm focused on the part where Mr. Witherspoon says, I'm not just basing this on my job, also I saw it, and also I'm certain of this. So let's just assume for a second that we do have Mr. Witherspoon saying that Connor was within a few feet of the Daniel asbestos work on a regular basis, 1 to 3 times a week and over a long period of time, and that there was at least some interaction with the workers. Would that be enough to meet Witherspoon in your, to meet the Lorman test in your view?
I don't think so, Your Honor, and I'll circle back to your question about the testimony, but assuming that the premise of your question that Mr. Witherspoon established that he was within 1 to 3 times.
Well, not that he established it, but a reasonable jury could draw that inference.
Yes, Your Honor. Right. That's 1 to 3 times a week within 2 feet. I still think there's a lot of gaps there about how long he was there, and Mr. Connor himself says he didn't stand and watch them. I think there's a lot of gaps there about what they were doing, which Judge Thacker points out. There's no testimony there about what the Daniel insulators were doing when they interacted, if again we assume that they interacted 1 to 3 times a week within 2 feet. Because I think it's important to remember here, and Mr. Witherspoon doesn't contest this, it's uncontested, there's no professional connection between Mr. Connor and the Daniel installers. He was supervising trainers who trained people in the main purpose of this plant, which was polyester production. The Daniel install statement as either observed fact or a reasonable inference, I think it still doesn't get plaintiff to the regularity and frequency that a lot of gaps that the jury would have to fill in. And so I think, and if you look at Lorman, they said that the 1 to 8 hours, 10 to 15 times, you can sort of multiply that on times in terms of minutes, that wasn't enough under Lorman to exceed the de minimis standard. So I think if we're in this area, then you have to entertain the plaintiff's argument that because this is a mesothelioma case, we need to dial down the level, the evidence of quantity that's required to get to a jury. And I think the problem for them there is, what is it that they want you to dial this down to? Lorman itself says it's a de minimis standard, right? There's got to be more than de minimis. So where else is there to go except to dial it down to say in the mesothelioma case, all you need is de minimis exposure. And I think the cases that we point to, the Ninth Circuit case in McIndoe, the Sixth Circuit case in Martin, the Seventh Circuit case in Crick, Texas Supreme Court in Bostic, the Pennsylvania Supreme Court in Gregg, they all say that this concept of de minimis exposure, that if that's the standard to get to a jury, that's irreconcilable with the concept of substantial causation, which is the causation level that's required under North Carolina law.
I guess I am really wrestling with this, and I'll bet you can help me. Just as sort of a matter of logic, I don't really understand how the Lorman test could not be disease specific. Because as you say, what it is sort of an application of the general principle that you need the kind of exposure that would give rise to a reasonable inference of substantial causation. That's what you're looking for. And so how could it not matter how the disease transmits when you're trying to figure out how regular, how frequent over what period of time, and how close you have to be to give rise to an inference that maybe that exposure is what caused your disease. You know what we've all just lived this with COVID. Like you can't ask in a vacuum, am I close enough to my coworker to give rise to a reasonable inference that I caught COVID from my coworker without knowing something about the 6-foot rule, right? Like that this is a disease that transmits within about 6 feet. How could it not turn, whereas if it were measles, like you could be 12 feet away and still get it. How could that not be relevant to figuring out how close is close enough, how frequent is frequent enough, and over how long a period is enough? That's my question.
Yes, Your Honor, I understand your question, and let me see if I can approach it in two different ways. First, I think it's important to remember that what we're talking about here is just the minimum standard level of evidence that you need to get to summary judgment. I think it is certainly, no one here is contending that it's not relevant when a jury gets this question and is considering what degree of frequency, regularity, and proximity is required, that the expert testimony, if it's admissible, will of course come into the jury's deliberation.
Okay, so it should be in the jury instructions, we think.
I think it, and that's obviously not the question here.
I understand, yeah, no, but this is helpful, okay.
I don't think anybody is talking about that question here. What does the jury consider when they're sort of pulling those levers on frequency, regularity, and proximity? But the question that we have here is not about where you fall on that, but what is the very minimum, right, that's required to even allow this question to go to the jury. And I think what Lorman says is, again, at least in asbestosis cases, that minimum standard is more than de minimis. And I think the question is, in a mesothelioma case, are you going to say that it's okay for that minimum standard to be lowered to de minimis? Because I think that's the only place to go. If Lorman says it has to be more than de minimis.
Well, can I suggest maybe another way you could think about it is that, like we talked about the jury and how the jury would be instructed and how I thought that was a good image, how it pulls the levers on proximity and everything else. Why wouldn't the question be, if a reasonable jury could find in light of this, the nature of this disease and how it transmits, if a reasonable jury could pull the lever for, yes, this is close enough, this is frequent enough, and this is over a sustained enough period of time, it should go to a jury.
Well, Your Honor,
that question should go to a jury.
I'm sorry, Your Honor. Well, I think with that, it gets to the second part, which I wasn't able to get to, which is, I think there's still a legal element to this, which is standards still to have meaning. And Your Honor, I think, and I don't want to go into detail with all of those cases, but I think if you look at those cases, this isn't entirely a science question when you're talking about the minimum standard that maintains some meaning for substantial causation and doesn't basically flip the burden such that defendants, because then they're now, every question is going to the jury on causation, that defendants are the ones that have to disprove causation. And I think in this particular case too, another factor that they point out in those cases is when you have a second source, a huge and undisputed second source, the substantial causation retained to the jury. And again, I think the Texas Supreme Court in Bostic explains this well, and they say, look, just as a matter of law, to ensure that substantial causation as a term and a legal element still has meaning, we have to require more than de minimis.
Okay, I think I understand what you're saying, and I want to give everyone else a chance. So so you're saying that sort of it's a legal rule that even if de minimis exposure can cause the disease, you still can't go to a jury on de minimis exposure, because that will just get us into a world of pain where, like, every employer will always be on the hook for everything. So even if there's a medical expert, a credible medical expert, even if we all know, let's say it's smallpox, like de minimis exposure is going to be enough to get you sick, you still can't go to a jury on de minimis exposure because the reasons you gave.
Yes, Your Honor. I don't know that I would put it in a practical way, the world of hurt, but I think what those cases say, and I agree with them, I think it's persuasive, is that it essentially renders this concept of substantial causation meaningless. And I think that's exactly, so it is, I think, something.
Well, Mr. Lynn, I don't know that I agree with that. I mean, it depends on the disease, right? It renders it it doesn't render it meaningless, it just applies it to the real world facts of the nature and the way in which a particular disease operates. And so it may be sui generis when it comes to mesothelioma, but there may be a different test when it comes to regular exposures not related to that particular disease.
Your Honor, I think my answer to you on that, again, leaning on a lot of those other cases, is I do think the disease matters, but I think you have to juxtapose that against this standard of what substantial causation means. And I think what those courts would say, and I think, again, the Texas Supreme Court says this explicitly, is that in order to ensure that it is both this question of law and science, and putting it together, that even in mesothelioma cases, irrespective of what the science says, although we have contested what the science says, and we did file a Daubert motion on that, so I think there's that question as well. But what these other cases say is that in order to ensure that substantial causation retains some meaning, you can't lower that standard for summary judgment all the way down to minimum. But,
so so say, I'm very bad at hypotheticals, so this one probably won't make sense, but run with me. Say like some company is doing something with like very scary chemicals. And they're deadly chemicals. And if you're exposed to this chemical, everybody agrees, if you're exposed to it for 2 minutes, you're going to get very, very sick. And there's a chemical leak. And so anybody like walking by this company on the street is exposed to the chemical for long enough to get very sick. But it all happens in like 3 minutes. In 3 seconds, you just walk by and that's enough. And all these people get really, really sick. And it's 100% clear that de minimis exposure to the chemical both could and likely did cause their illness. But you would say, like, that's de minimis. I'm sorry. It was only a couple of seconds one time. You're not going to a jury on that. Is that where we are?
Your Honor, I think, well, a couple answers to that. I think, one, I don't think the science is that clear on asbestos, but two,
I know, but this is a hypothetical. Yeah,
I understand you're right, and so two, I think again, that's what court after court has said. But
how can that? But if we're how? But at least in North Carolina, right, the rule is substantial causation, and if it's clear that my de minimis exposure was a substantial cause of my illness, why can't I go to a jury? I mean, there might be some other reason, some other legal reason, but on causation, I can't go to the jury because it was de minimis?
Your Honor, that's, again, I think if this court were to adopt that rule, it would be really contradictory to all of these cases in the brief. But I think, Your Honor, if I may, because I don't have a lot of time left, come back to the evidentiary question. I don't think this court needs to reach that issue in this case, because I think that the evidence that we're talking about, and Judge Harris, you asked me to assume for the sake of argument that he had seen this happen. There is one statement where he is asked, is this based on your observation of what Pete Connor did? He says yes, but I think the question of what he understood by observation isn't clear when you read it in context. And if you look 2 pages earlier in the JA, 384, he's asked specifically about, would you say Mr. Connor was near Daniel and Stollers? He says, I think so. And then he's asked, did you see him do that? And he doesn't answer yes. He says, I think this is something that both of us would have done in doing our jobs. He then goes on for the next 4 pages talking about the type of job that he did and to, why he reaches this guess about what Mr. Connor was doing. And so I don't think you have the evidence here that is any more than just his belief. And the question is, from the jury's perspective, does the jury have the facts that would allow them to draw this as a reasonable inference that Mr. Connor was near the Daniel and Stollers 1 to 3 times a week, that he was within 2 feet, that he spent time around them, he didn't just stopped and watched them, and that they were doing their work? And I think there's too many gaps in the evidence for a jury to reach that reasonable conclusion. So I think on that basis alone, you could conclude that there's not enough here to put him close enough, as Rowling said, to conclude that he was breathing the asbestos dust. Because asbestos, Your Honors, is not like radiation. It's dust. It has to be inhaled. It's not everywhere in the plant. Ms. Shirley's not contending that. In her footnote in their reply brief, they say specifically, we're not saying that it was throughout the entire manufacturing plant. Their theory of exposure depends on 2 things. One, that there was airborne asbestos around the Daniel and Stollers, and 2, that there's enough evidence to put Mr. Connor close to it. And again, I think this is very much like the Pace case, where this court pointed to somebody's testimony where he said, I can't remember seeing him connect to specific pumps, but I know he did it and I seen it. That's what the Pace testimony was. This court said that's too speculative to send that question to the jury. And Judge Harris, if you want to think about it as proximity under Lorman or separately as an actual exposure question, I think under both standards, you don't have him close enough to even establish that there is this de minimis exposure. And I think you don't have to reach in this case the mesothelioma question. I see my time has expired. I'll listen for the question.
Thank you, Mr. Lynn. Ms. Shirley, you've got some time for rebuttal.
Thank you. I wanted to quickly clarify that this is not a de minimis exposure case. Even though these were short exposures, they were quite high exposures. And one of the things that the trial court did not consider and was not challenged in any kind of Daubert way was our expert's opinion that Mr. Connor had frequent, recurring, and substantially elevated air concentrations of asbestos as a bystander at Viber. That is based on all these studies and everything that's in the record, but that's at JA 1899. So that opinion should give some comfort to you if you're doubtful that even these short exposures, if you think those aren't a lot, that medical evidence is that they are quite high, and they are causative of people of mesothelioma and bystanders, even family members.
But the testimony out of Mr. Connor's own mouth is that when he saw Daniel International workers around the facility, he would not stand and watch them. And he didn't have any dealings with them or speak to them. They did their work and we did ours, he said.
Well, he was somewhat internally contradictory on that. He did also talk about...
Okay, I'm sorry, go ahead.
I was just going to say, as I pointed out before, he did testify about having a lot of direct contact with them in terms of helping them do repairs, giving them permission for repairs.
And did you say that was how frequently?
Well, he said that he saw them every day. I mean, there are some inferences that have to be drawn, but he said he saw them.
He also said some days I wouldn't make any passes through the production plant area. It's a pretty big plant, and that he worked most of the time in the P building, which didn't have asbestos.
I mean, that's right. We're not contesting that he primarily worked in the P building. But we are saying that even the times that he was around Daniel was enough to cause his disease. And that is in the record at 324, 326, and 27, where he's discussing those direct interactions that he had with Daniel workers. In terms of Witherspoon, in his opinion, not only was it based on personal observation, it was also even the testimony based on the fact that he did a similar job, we think is admissible. It is a lay opinion based on his personal perception, rationally based on the witness's perception, and helpful to determining a fact and issue. That's Federal Rule of Evidence 701. He knows the job, he'd seen it done, and he has authority and personal knowledge.
Did I understand your answer to Judge Harris's one of Judge Harris's questions correctly a while ago? Did you say that even if we don't consider mesothelioma, that you should prevail on summary judgment based on his exposure? Or do we have to consider mesothelioma as a disease for you to prevail?
Well, Your Honor, I do think we prevail, even if you don't consider it. But I think if you do consider it, we are encouraging the court to consider it because that is a relevant factor in determining whether those short exposures, if those would be causative. I was going to point the court to the Finch versus Koval opinion. And this court had affirmed the jury instruction that was given in that case. It was actually quite a similar case by situation. And there, the district court had really been the one to draw the distinction between asbestosis and mesothelioma. But the district court's instructions in Finch, those are quoted in this court's opinion at 972 F3rd, page 513. And those list out all the factors that the jury should consider, such as how much Koval insulation was in the plant and how close the plaintiff was to it, et cetera, et cetera. Those same factors I would encourage the court to use here in evaluating whether this exposure meets the Lorman test.
Counsel, can I ask you, I just want to clarify something you said. You're talking about the circumstances under which you would prevail on summary judgment. You're not asking us to say that the district court should have granted the plaintiff summary judgment, right? You're asking us to, you're saying this is enough to get you to a jury to defeat a motion for summary judgment. Okay, I just want to make sure. Okay.
Absolutely. Sorry if I misstated.
No. I clear from context. I just want to be certain.
All right. I have one more small point to make. Would it be okay if I went on for another minute?
Go ahead.
Thank you so much. I just wanted to point out that the Bostic case that was mentioned by opposing counsel, that was not a Lorman case. Texas doesn't use Lorman. Texas uses quantify. They make you quantify your dose, whereas Lorman is a qualitative standard that most other jurisdictions based on a test. So I just want to clarify that, and also clarify we are not relying on any opinion that each and every exposure is a substantial factor in causing disease. Our expert didn't say that, and we're not arguing that in any way.
Thank you, Ms. Shirley. I want to thank counsel for their arguments in this case. The matter is submitted, and we would again normally come down from the bench and greet you personally, but we can't do that. But again, on behalf of the court, my thanks for your able presentations this afternoon. Be well and stay safe. Thank you very much. Judges Thacker and Harris. All right, Mr. Huara, are you on the line to introduce the students who will be arguing this case?
I am, Your Honor, and may it please the court.
Okay. Yes, sir.
Daniel Huara on behalf of the appellant, Marcus Crawley. It's my distinct pleasure to introduce Jennifer Hartley and Christopher Collum, third-year law students at Washington University in St. Louis, who will be arguing the case on behalf of Mr. Crawley.
Thank you, sir. Ms. Hartley?
Yes, Your
Whenever
Honor.
you're ready. Whenever you're ready, go ahead.
Good afternoon, Your Honors, and may it please the court. My name is Jennifer Hartley, and I represent the appellant in this case, Mr. Marcus Crawley. We're here today asking this court to vacate the sentence for Mr. Crawley's constitutionally infirm Section 924 conviction because it relies on the now invalid predicate of conspiracy to commit Hobbs Act robbery. The district court erred by searching through non-elemental facts accompanying the plea agreement to try to support the conviction with a dismissed drug trafficking charge. Because the commission of a drug trafficking crime was not an element of Mr. Crawley's 924C conviction, any of the plea agreement's facts related to alleged drug trafficking were superfluous and could not be relied upon to support his conviction years later after a change in the law. The decision below had the effect of finding Mr. Crawley guilty of trafficking drugs without proof beyond a reasonable doubt after he pled not guilty to the underlying drug trafficking.
Excuse me, this is Judge Thacker. Before we get to the merits, isn't there a procedural hurdle that you need to get over that the government has argued?
Your Honor, the government did bring up procedural default in its brief, and our position first off is that this court should not consider that issue in the first instance because the government did not argue procedural default in the district court, and so it has not been considered before. And if this court does decide to consider procedural default, we also believe that there is no procedural default issue here. So very recently, this court decided the case of United States versus Taylor, which is very similarly situated to our case procedurally. The government raised the same procedural default issue that it has raised here, and this court found that argument so unavailing that it didn't even feature in the opinion. But regardless, we feel that our client has can establish both cause and prejudice to excuse any procedural default. And as I was saying,
wait,
Hartley,
I'm
can I
sorry,
ask
when,
you-
what is your?
Go ahead,
Judge
just
Diaz.
Thacker. Go ahead and finish your thought. Go ahead.
And what is your cause and prejudice?
Sure. So under the cause prong, the argument that our client is making was not available in any sense of the word back when he was sentenced in 2008. So he was sentenced just shortly after the Supreme Court's decision in James, which specifically foreclosed this argument about the unconstitutional vagueness of clauses like the residual clause. And then our client filed his application to file a successive 2255 motion shortly after the Supreme Court's decision in Johnson. And in Johnson, the Supreme Court effectively overruled its previous decision in James. And so in that sense, there was cause because the claim was foreclosed before that decision in Johnson. And then the prejudice here is plainly that our client is currently in prison on an unconstitutional charge and thus is serving time under a conviction that can no longer be constitutionally supported. And in attempting to defend the decision below, the government repeatedly points to its conjunctive wording of 924C's disjunctive components.
So, Ms. Hartley, can I ask about something you said earlier, and that is that you say that the drug trafficking charge is not an element of the underlying 924C offense. So I guess I'm having trouble understanding why that's the case. I mean, it was pled, right, in the conjunctive as part of the indictment. And so why wouldn't it be an element of the 924C charge? The way I see this case is, and you didn't focus on this in your brief, and I guess I'll ask you why, isn't the real problem here that even if the government is relying on that alternative predicate, that the elements of that alternative predicate were not, the defendant in this case never admitted to all of the elements of that predicate, and in particular, never admitted during the plea colloquy, never admitted to the element of intent to distribute. All the statement of facts talk about is that there was an amount of drugs that they attempted to rob and in the apartment that amounted to more than, perhaps one could infer, more than a personal use amount, but that's it. So why isn't it as simple as that? He never actually admitted to the element of intent to distribute, so even if the government could use this as a predicate, it fails for want of a valid plea by the defendant.
So that's exactly right, Judge Diaz. And we think that it's, there are both of those.
Well, but I guess whether I'm right or not, I guess is a separate question. My two colleagues may disagree, but I didn't get that. It didn't seem like that was sort of the focus of your brief, and maybe I just misunderstood that. So you agree with that? This is really about a Rule 11 plea issue and whether or not the defendant actually admitted to the elements of that alternative predicate when he first pled guilty. Is that fair?
We think that there are multiple issues here. So one of those issues is that first point that you raised, asking about why the drug trafficking crime was not an element of the conviction. And so under the statutory language of 924C, 924C criminalizes conduct with a firearm during and in relation to a crime of violence or a drug trafficking crime. And so in this case, that element that it needs to be in relation to a crime of violence or a drug trafficking crime was satisfied with the Hobbs Act conspiracy charge, which at that point qualified as a crime of violence. And so under the guidance we have from the Supreme Court about what is a non-elemental or superfluous fact in the Day Camp case, anything after we had that crime of violence satisfied for the element would have been a non-elemental fact. And so because that drug trafficking crime, I don't think the government would dispute that there are people incarcerated right now on 924Cs in relation to a crime of violence. So the drug trafficking crime was non-elemental. And then there are further issues here in that there was no proof beyond a reasonable doubt of the drug trafficking predicate. And as Your Honor pointed out, there is no proof of the elements of that crime on the record. And so both of those things are issues which make this conviction constitutionally infirm. And that's why we're asking for it to be vacated.
Counsel, is your argument, oh, I'm sorry, go ahead, Judge Diaz.
Sounds like what you're arguing, though, is that if in fact the defendant had admitted to each and every element of that drug trafficking offense at the plea hearing, your argument would still be that because the 924C conviction was satisfied initially by the Hobbs Act conspiracy offense, even that admission would still render this offense defective because it's not an element of the 924C count. Is that what you're saying?
Yes, that's right, Your Honor. So because anything related to the alleged drug trafficking would have been superfluous facts, our position is that it was improper for the district court to rely on those because, as the Supreme Court has instructed, a defendant who pleads guilty only to the elements of the crime to which they are pleading and not every fact offered by the prosecution. But as Your Honor has pointed out, there is the additional issue here in that there is no proof beyond a reasonable doubt of the elements of the underlying drug trafficking crime that the government is now seeking to rely on.
Well, I just want to make sure I understand your argument on that second point. So he pled guilty to count 3, and count 3 says that he used a firearm in connection with both a crime of violence, Hobbs Act conspiracy, and also during and in relation to a drug trafficking crime, to wit, attempt to possess with the intent to distribute a controlled substance. So he pled guilty to that, to attempting to possess with the intent to distribute a controlled substance. So why isn't that enough?
Because he pled guilty to count 3, which essentially charged
that's what I was
crimes.
Reading.
Yes,
but I was So he pled guilty to that.
Yes, and the problem with count. I'm sorry. Go ahead.
No, I'm sorry. You go.
And the problem with count 3 is that it essentially charged 2 separate violations of 924C in one count. And so
okay, so you have a problem with the form of the indictment, but I'm trying to get to I guess what I think Judge Diaz was talking about, which is like, what did he plead guilty to here? And so I guess, is it your argument that did the district court judge need to say in taking a plea to attempted possession with intent to distribute, did he need to say, look, this was, I can't even remember what it was, but half a kilo of drugs or something, and and we agree, right, that if you try to take that much, if you try to steal drugs in that quantity, that means you intend to distribute it? Did the district court need to kind of put this on the record, this inference from the amount of drugs to the intent to distribute? Is that the problem here? Or are you saying that like a reasonable jury or judge could not infer from the quantity of drugs at issue here an intent to distribute?
Well, I think that the problem is that the statement of facts in the plea colloquy do not make out the elements of this charge. So if you look at this,
it has the drug quantity in it. So are you saying that the drug quantity is not enough? You can't infer from the drug quantity the intent to distribute?
Our position is that there is no proof beyond a reasonable doubt based on the way that the government structured this charge. And in other places in the statement of facts, for example, paragraph 18, which is on page 42 of the joint appendix, the government was very specific in getting our client to stipulate to the fact that the firearm was a firearm within the meaning of the United States Code and things like that. And there is just no specificity at all in relation to this alleged drug trafficking crime. And if the government wanted to attempt to prove a drug trafficking crime, It could have done so in this statement of facts that it crafted, and it did not do so. And so,
Well, I'm sorry, I'm only going to, I promise. Yeah, good.
I'm sorry.
No,
go ahead. Go ahead,
go,
Judge Harris.
No. Go.
So you're talking about proof, but this was a plea. It was a guilty plea. And so the issue is whether or not the defendant admitted each and every element of the offense, to include the trafficking offense. And if a judge has to infer whether or not the intent to distribute occurred, then that doesn't sound to me like there's a factual basis for the plea.
That is correct, Your Honor. And the factual basis of the 924C charge could have been adequately supported in 2008 with the Hobbs Act conspiracy charge, because you do not need a crime of violence and a drug trafficking charge to support a 924C conviction, which is why the drug trafficking crime was non-elemental to the 924C conviction. And in fact, the drug trafficking crime, that underlying predicate, was dismissed, and our client pled guilty to the Hobbs Act charge. And so the Hobbs Act charge was that proof underlying to serve as a predicate, a crime of violence predicate at that time, for the 924C conviction. And so the district court judge back in 2008 had the necessary elements of a 924C conviction with that Hobbs Act conspiracy charge. The problem is that now we know that Hobbs Act conspiracy is not a crime of violence under the Supreme Court's decision in Davis and this court's decision in Sims. And so I will just briefly also mention that this court's precedents in Ban and Chapman have been clear that the government's choice to use the conjunctive and in place of the disjunctive or do not mean that a defendant admits to all of the.
Well, it's not the government's choice. That's actually how indictments with disjunctive elements in a statute are required to be indicted, right? They're required to indict in the conjunctive the disjunctive components of an underlying statute, but that doesn't mean that we don't, the courts don't consider guilt disjunctively, correct?
Yes, Your Honor, that is correct. And so under this court's precedents, that and is not sufficient for the government's conclusion or the district court's conclusion that our client necessarily pled guilty to this underlying drug trafficking crime, when again, the government admits in its brief that it could have separately charged 924C in relation to a crime of violence and a drug trafficking crime. And if there are no further questions, I'll reserve the remainder of my time for rebuttal.
Thank you, Ms. Hartley. Mr. Grano, I hope I'm pronouncing that right. We'll hear from you.
Thank you, Your Honor. May it please the court, I'd like to start with a couple points that I think are useful to frame the doctrines that we're operating in, and then I'd like to turn directly to Judge Diaz and Judge Harris's questions about sort of the sufficiency of the factual basis and what the judge had to say at the plea. The first point I think is critical, that this is not an actual application of the modified categorical approach. The question here under Bowsley is whether the defendant's plea was knowing and voluntary, whether he was properly instructed as to the elements of the offense, and whether he voluntarily made that choice to plead guilty. Here, the defendant was charged in the conjunctive, as we are required to do, and then admitted expressly that his conduct violated both with respect to the Hobbs Act robbery conspiracy and the attempted drug trafficking, and then that he did so with the requisite intent, and that there was
you're saying that appellant admitted to the drug trafficking offense?
Yes, Your Honor. In paragraph one of the statement of facts, he admits that his use of the firearm was in furtherance of both the crime of violence and the drug trafficking predicate. So, and then subsequently in the facts, he admits that his conduct and his use of the firearm was to obtain 0.5 kilogram of cocaine, which is more than sufficient under this court's precedents to establish an intent to distribute under both.
Can I ask about that? So you say
yes,
under this court's precedents, but aren't all those cases questions that went to a jury or a trier of fact as opposed to a guilty plea?
Yes, Your Honor, but I'd like to add in some other context about how the factual basis for guilty pleas. And we are far afield from, I think, the issues that were briefed. So I apologize that some of this is coming up for the first time. So the first point is in United States versus Lamar from 1996. This court held that a quantity exceeding 5 grams of cocaine was sufficient to support an inference to distribute. And more recently in 2014 in Fields, a kilogram, which is about 10,000 street doses of crack.
I don't have any dispute with that. I agree completely with those propositions. The question is it sufficient in the context of a guilty plea, where the most direct way of getting to that point is, Mr. Defendant, when you robbed these individuals of these drugs, did you have the intent to distribute them later on? Why do we need an inference?
So for this point, Your Honor, we turn to 2 cases. The first is United States versus Wilson from 1996, and the second is United States versus Carr from 2001. So under Wilson from 1996, a court is not required to state every single element of the offenses in a Rule 11. They're accorded broad discretion in how they construct their Rule 11 colloquy. And then in Carr, this court held that the factual basis for a plea does not need to cross the beyond a reasonable doubt threshold or even the preponderance threshold. It simply has to be, the judge has to be satisfied that the conduct as stated constitutes an offense under the statutory provision that's cited. So if the judge hearing
didn't mention the amount of the quantity of drugs as being a basis for intent to distribute here, the district court focused on the violent nature of the crime, and so
yes, Your Honor. Although I would point out that in the plea colloquy at pages 18 to 19, the court recited all of these facts and then asked the defendant whether he agreed that this is what happened, and then also asked the defendant in the course of the plea colloquy whether he admitted that he was guilty of the offenses as charged, after specifying in the Rule 11 colloquy itself that both predicates were the basis for count 3. So I do think that the elements of all of the predicates were in front of the court and in the court's mind. And this
but the court didn't make that finding, that leap or that finding that you're asking, that you're arguing, that is, that the amount of drugs alone was enough to show intent to distribute, correct?
Well, yes, Your Honor, in the sense that the district court did not make it explicit. I do think under Lamar, it is sufficient as a matter of law, and the district court could then rely on that. If the court's concern is that the court's Rule 11 colloquy was not sufficiently clear that the district court made that particular finding, that actually falls under the second part of Carr with the 2-remedy rule. And this is where we're really far afield. But under the 2-remedy rule, if the district court fails to make a specific finding, and this court is not convinced that the district court actually found a portion of the factual basis for the plea, the remedy is to vacate the conviction and sentence, but not the guilty plea or the plea agreement, and to remand for the district court to make that determination on the record, or for the government to produce additional evidence to support the missing facts from the colloquy. That's different from the question of whether or not the defendant understood what he was pleading guilty to, in which case the guilty plea is itself vacated. So now, it's very complicated, but...
Well, what about our case, United States versus Chapman, that says when a defendant pleads guilty to a formal charge in an indictment which alleges conjunctively the disjunctive components of a statute, the rule is that the defendant admits to the least serious of the disjunctive statutory conduct. Here, the least serious would be that Hobbs conspiracy, not the drug trafficking offense.
2 points, Your Honor. One, both Van and Chapman occur in a context in which there is no other evidence in the record about which predicate prongs alternative theory the defendant actually pled to, whereas here we have the plea agreement, which explicitly states both, the statement of facts, which expressly admits that he did it in furtherance of both. So I would say Van and Chapman are distinguishable on their facts. The second point about Chapman is that it occurred in a very different context of a constitutional challenge, where the court was attempting to analyze whether the government had a reasonable means ends fit between a second infringement on a Second Amendment interest and a particular prohibition on the possession of firearms. So the court was essentially assuming, does the Second Amendment allow a restriction on this particular type of conduct. And to do it, they assumed what the court found to be the least serious conduct, which is being subject to a protective order saying you couldn't possess a firearm. So again, it's a very different context than when on collateral review, we're reviewing whether or not a defendant knowingly and voluntarily pled guilty or whether he had a factual basis. On the factual basis point as well, I'd point out that this court's opinion in Mitchell cites the court's opinion in Willis, which says that a defendant actually cannot challenge the sufficiency of the factual basis for his plea on collateral review. He can only challenge a defect in the Rule 11 colloquy itself. So the law here is actually very clear that when a defendant is raising a collateral challenge and says that my factual basis was inaccurate, the court is actually only reviewing the Rule 11 colloquy to determine whether or not it was adequate, not whether or not there is in fact a factual basis for a plea. The other point that I'd like to put in front of the court is that because this is occurring on collateral review, the burdens are vastly different than if this question had come up on direct appeal. So because the defendant bears the burden in collateral proceedings and in fact is subject to requirements that far exceed even plain error review, the defendant bears the burden of demonstrating that he was either actually convicted only under the defective theory or that neither theory is permissible at all. And because we're dealing in that context, I think this sort of it animates the principle of procedural default that we've raised. It animates the harmlessness analysis at the end of our briefing. But at its core, it's that the defendant was instructed that both of these predicates could be the basis for his offense.
I'm sorry, I just want to go back to the statement of facts again and make sure I understand the government's position. So the statement of facts says that the purpose of the home invasion was to rob the victim of money and narcotics, and that it was the appellant's intent to steal the cocaine and drug proceeds. There's nothing in there specifically that says the intent was to traffic these drugs. There's nothing in the statement of facts that specifically says that. So I just want to make sure I'm understanding the government's argument correctly. The only evidence of intent that the government is inferring, intent to distribute, is the amount of drugs. Is that correct?
Yes, Your Honor, coupled with the fact that the defendant admitted in the first paragraph that his use of the firearm was in furtherance of the drug trafficking predicate. So again, it's that he admitted that he was guilty of the count as charged as to both the crime of violence and the drug trafficking predicate, which was charged as attempt to possess with the intent to distribute.
Right, because you charge in the conjunctive, but you prove in the disjunctive, and guilt is in the disjunctive. And under, we already talked about the one case that if there are two statutes in the guilty plea, it's the least serious offense that he has pled guilty to, which is Hobbs' conspiracy.
I disagree.
And I understand your response to that.
Yes, so
you
I
had several
think
responses to that.
In the absence of evidence, the Van Chapman rule has different effects, but we think that the admissions in the statement of fact, its inclusion in the plea agreement explicitly as both, and his statements at the Rule 11 colloquy all indicate that he was actually pleading as to both. So as Your Honor knows, we can always include a special verdict form, for example, when it goes to the jury, and the jury can convict on two theories. So it's not always true that guilt is disjunctive. Guilt can be conjunctive on alternate theories. And we think that his admissions, the language of the plea agreement and the Rule 11 colloquy here all fill that gap to say that this was effectively the same thing as a special jury verdict, finding that both predicates were satisfied. And the district court's confirmation of that fact during the Rule 11 colloquy is what's adequate to sustain the conviction as on both theories. So this would be the exact same thing as Hare, in which the jury found both that the drug trafficking predicate and that the robbery predicate were the basis for the 924C action. I don't think that a special jury verdict is necessary as well, because if we look also in Hare to the earlier proceeding, there was an argument that there was Rosamond error in the jury instructions as to aiding and abetting the 924C argument. But the court sustained the conviction, saying the evidence was also sufficient to establish Pinkerton liability, which was a separate theory of liability on this offense. In that context, because plain error placed the burden on the defendant to prove that he could not have been convicted under Pinkerton liability, that was sufficient to sustain the conviction, even in the absence of a special jury verdict. Here, we think it's the exact same thing. On the basis of, on collateral review, where the defendant bears the burden to demonstrate that his plea was knowing and involuntary, he would have to demonstrate that he pled only to the invalid predicate, or that both predicates themselves were invalid. We don't think he could do that on this record. Yes, Judge Harris.
Can I ask you a question? And it's another way of thinking about what happened at the plea colloquy here and the statement of facts and everything. So I sort of agree. What we're trying to figure out is whether it's clear that he pled guilty to both of the predicates and not just one. And there is sort of a common sense argument, right, that when you look at the indictment and then the plea agreement, right, he pled guilty to the substantive Hobbs Act violation, the crime of violence. He did not plead guilty to the substantive drug trafficking crime. So just as a matter of common sense, one might assume that when he pled guilty to the 924C1, it was on the basis of the predicate to which he had pled guilty and not the predicate that was dismissed. And then you look at the plea colloquy, and you also might sort of assume that if in fact everybody's understanding was that he was pleading guilty to the trafficking predicate, somebody would have said something, like maybe the magistrate would have mentioned the intent to distribute and made sure he was pleading guilty to it, or at least mentioned the 0.5 kilogram or more of cocaine, just something about it. And instead there's this kind of notable silence. And I'm just wondering whether or not, I actually have not recently read, but I think I have some dim memory of some of the cases you're talking about and what happens at the Rule 11 colloquy. And even if you weren't going to say that there was sort of a Rule 11 problem here, he didn't plead guilty to it, since we're trying to kind of infer from this record what it was he pled guilty to, could we take account of that omission at the Rule 11 colloquy, that nobody said anything about intent to distribute or about the quantity of drugs involved or any inference from that quantity, that it was just kind of dead silence on that point?
Your Honor, I think I would have a harder argument if the drug trafficking predicate were not mentioned at all. But at page 8 in our supplemental appendix, it was specifically mentioned as a predicate for the count. And then immediately afterwards, the defendant was asked whether he agreed, whether he was pleading guilty because he was guilty of the offenses as charged. And so I think it's one of these whole record evidence analysis that you have to do, because again, what we're doing is we're reconstructing sort of what was in the district court's mind and what was in the defendant's mind at the time that the Rule 11 conflict happened. I do think it's important to point out, with respect to your judge's question, that who has to show what was clear is again doing a lot of work on collateral. The defendant has to show that it was clear that he was only pleading to the invalid predicate in this context. And because of that, I think, again, if we were on direct review, it would be very easy for this court to just vacate and remand for a new Rule 11 colloquy, make it clear, and things would be squared away. But as the Supreme Court has pointed out, and most recently in Weaver versus Massachusetts in 2017, there are real costs to vacating a conviction long after it has become final. The passage of time blurs witnesses' testimony, documents or evidence may be lost, and so that's why there's a higher standard on collateral review to go back.
Mr. Brano, can I just ask you what you just said a few moments ago? Earlier, I thought I heard you say that you thought the colloquy in this case was sufficient, even perhaps on direct review, but now you're suggesting that perhaps it wasn't, but it's good enough because this case is on collateral review. Is that the government's position?
No, Your Honor. Our position is that it would be sufficient even on direct review, but there are additional hurdles to cross when you're on collateral review because the burden has shifted as to who has to demonstrate the clear insufficiency of the Rule 11 colloquy. So our position would be under Wilson and Carr that the district court was not required to make a specific explicit statement about intent during the Rule 11 colloquy, and that under Carr, the inclusion of language about the 0.5 kilo of crack cocaine would be sufficient to then support an intent to distribute, and therefore there was a factual basis for the plea. The thing that's different about the collateral review context is Willis then says the defendant cannot go back and argue the factual basis for my plea was insufficient. He has to argue only that there was a defect in the Rule 11 colloquy. So we're sort of 7 layers away. And because of the interest and finality that exist in criminal judgments and the problems with vacating a conviction that's now more than 12 years old, we think that it's appropriate in this context to hold the defendant to his burden to demonstrate that his conviction was in fact invalid. I'd like to return just very briefly to the issue of procedural default, since this was raised with my colleagues on the other side. Under Green Law versus United States, the Supreme Court has held that an appellee can defend a judgment below on any ground, even if it's not raised. So even if we had said nothing about procedural default in the district court, I think we are still entitled to raise it on appeal, but we did. In our motion to dismiss, which was specifically on timeliness grounds, we expressly reserved our right to assert procedural default to these challenges. And this court has, in fact, recognized procedural default, or at least considered these issues on appeal when they've been raised in the first entrance. The first time was in Fugit in 2012, in which we raised procedural default, and the court addressed it and disposed of the question on that. And then recently, just last year, actually in Salas, where this court made a finding that under the Metzger factors, judicial efficiency, conservation of scarce judicial resources, and the orderly and prompt administration of justice warranted considering a procedural default offense for the first time on appeal. So this is not a situation in which the government sat on its rights or did not raise the argument affirmatively below. The posture is merely a result of the fact that the district court concluded as a straightforward application of error, the defendant's argument simply didn't have a legal basis, and so summarily dismissed on that grounds without even the government having to brief the merits, and solely after it had done a motion to dismiss on timeliness. If the court has no further questions for me, we will rest on our briefing.
Thank you, Mr. Brano. Mr. Collum, sir, we'll hear from you.
Thank you. Good afternoon, and may it please the court. My name is Christopher Collum, and I also represent the appellant in today's case, Mr. Marcus Crawley. As Ms. Hartley just explained a moment ago, this case concerns Mr. Crawley's continuing incarceration for constitutionally infirm conviction. We now ask this court to vacate his conviction and his sentence on his 924C count. This is not a case where we are questioning the sufficiency of the evidence that the government presented at the Rule 11 plea colloquy. There's no question that the predicate offense of conspiracy to commit Hobbs Act robbery is no longer a constitutionally valid predicate after this court's decision in Sims and the United States Supreme Court's decision in Davis. There's also no question that Mr. Crawley pled not guilty to the drug trafficking offense, the count 2, that it was dismissed as part of the Rule 11 plea agreement. There's also no question that when the judge below read the plea colloquy, read the plea agreement aloud at the Rule 11 plea colloquy, Mr. Crawley pled guilty to counts 1 and to count 3, but pled not guilty to the other counts, and they were dismissed. Furthermore, the judge did not make any mention of the quantity of drugs that the government alleges Mr. Crawley and his co-defendants intended to steal at the plea colloquy. So while it's true that the drug trafficking offense was mentioned in passing, simply when the judge read out the 924C conviction that is structured such that it includes both the Hobbs Act robbery and the crime of violence and the drug trafficking crime, there was no mention of any amount of drugs, and there was no allegation that Mr. Crawley intended.
Wasn't the amount of drugs mentioned in the statement of facts to which Mr. Crawley pled guilty?
Yes, Judge Thacker, your Honor is correct that the amount of drugs was alleged in the statement of facts. At one point it says half a kilogram, at another point it says half a kilogram or more. However, under the Supreme Court's precedent in United States against DeCamp, a defendant pleads guilty only to the elements of the crime. And those are non-elemental facts, any information about the drug trafficking charge or any amount of drugs. And that's true because the 924C conviction was already supported by the Hobbs Act robbery to which Mr. Crawley pled guilty. So therefore, any information about the drug charge is superfluous to the 924C conviction. And so it would have been inappropriate for the sentencing judge to rely upon that. And it was inappropriate, as we can see on page 99 of the joint appendix, with the judge below in dismissing Mr. Crawley's 2255 petition to then essentially find Mr. Crawley guilty of the drug trafficking crime beyond a reasonable doubt years after the fact. The problem here, and why we're even discussing this, is because the government is essentially trying to reconstruct its plea deal years after the fact, because now the predicate to which Mr. Crawley did plead guilty is no longer constitutionally valid. If the government wanted to charge Mr. Crawley with a 924C based upon the drug trafficking charge, it could have brought two separate 924C convictions, as Ms. Hartley mentioned. The government regularly does this, and it admits in its brief that it is allowed to do this. And when this court a few months ago considered the Taylor case, in that case, that was exactly what we had. But that's not what the government did here. What the government did here was that it brought one 924C.
Counsel, can I just ask you a question? I mean, it seems like this case would be a lot more straightforward. You say the government wants to redo the plea agreement, but the plea agreement could have said what you say it says. It could have said, I'm pleading guilty to the 924C count based on a crime of violence, period. But it doesn't say that. That's not what he pled guilty to. So it seems as though, I mean, maybe I'm missing something, but you would like us to do some editing of the plea agreement, right?
Well, Your Honor, it's true that the plea agreement says crime of violence and drug trafficking crime in the 924C charge. But it's our position that the most natural reading of the plea agreement is that everything from the and after drops out because Mr. Crawley pled not guilty to the drug trafficking charge. And so it's only the crime of violence language that's relevant there. And that are supported or were supported at the time by the Hobbs Act robbery, the conspiracy to commit Hobbs Act robbery charge. And so anything after that would be a non-element and to vacate Mr. Crawley's conviction and his sentence. Thank you.
Judge Diaz, we can't hear you.
Everything's frozen.
Yeah, I got frozen too.
Can you hear me now?
I can hear you now.
Okay. You know, I said I had put together such a grand speech, and now I have to repeat it. I simply wanted to thank Washington University School of Law for taking on this case as court-appointed counsel, and in particular wanted to thank the two students who so ably argued the cause on behalf of their client here this afternoon. I also want to thank Mr. Grano for ably representing the government in this case. We could not do the work that we do without competent counsel coming before us and representing the interests of both defendants and the government, and that certainly happened this afternoon. So again, thank you on behalf of the court, and be safe and be well. We typically would come down and greet you personally, and particularly love doing that when it comes to students, but obviously we can't do that this afternoon. But thank you very much on behalf of my colleagues and on behalf of the court. Take care.
Thank you, Your Honor.
Thank you, Your Honor.
We're going to move on. Calendar this afternoon is Billups versus the United States of America. Mr. Spinelli, whenever you're ready.
Yes, thank you, Your Honors. Good afternoon. I'm happy to be here today on behalf of Dr. Billups. The facts of the case would actually be entertaining, except for the tragic consequences of what occurred. Essentially, Dr. Billups was visiting the United States Postal Service when he saw an employee's truck that honked in a very loud way. Dr. Billups then went over to the employee's truck and inspected the front grille of the truck. The truck was parked in backwards. And when he bent down to inspect the grill, the alarm of the truck went off in a very high volume. And upon further inquiry, he learned that one of the employees at United States Postal Service, Mr. Kane, had, for Mr. Kane's amusement and the amusement of other employees at the Postal Service, put a hole in the Venetian blind next to his office so that he could watch when other employees would walk by his truck.
Right. So how is that? This is Judge Thacker. How is all of that, putting a hole in the blind so he could watch when he set off the alarm when people got near it, not an intentional act? How is that negligence?
Yes, Your Honor, and I appreciate the question. The question itself, the way it was addressed at the lower level was to define that as a series of volitional acts. As a volitional act, the lower court judge argued, as a volitional act, that places it outside of the scope of the Federal Tort Claims Act. However, there was no authority cited for that broad extension of the Federal Tort Claims Act.
Okay, I guess my question was, how is it negligence?
Right.
You're alleging negligence. How is it negligence then?
We have, Your Honor. It's a negligent act of horseplay by specifically activating his truck horn. It was negligent in that it...
Specifically activating his truck horn sounds intentional.
It is a volitional act, but the fact that it was a volitional act to activate the horn does not place it outside the scope of the Virginia Tort Claims Act itself. Specifically, it appears that what the judge relied on was the idea that anything that arose from an assault or battery within the meaning of the Federal Tort Claims Act would preclude recovery under that. However, the issue here is, as Judge Thacker points out, one of the issues is simply because there's volitional contact involved, that does not render it an intentional act outside the scope of the Federal Tort Claims Act.
I don't think I said that.
Oh,
yeah, go ahead.
No, counsel, I can't tell which of two things you are saying. Are you saying that this conduct was not intentional, or are you saying just because it's intentional doesn't take it out of the scope of the FTCA?
Thank you, Your Honor. The latter, simply because it's an intentional act or some associated volitional act does not take it outside the scope. But the real issue here...
Mr. Spinelli, can I ask a different question, which goes back to the very description that you began with, for his own amusement, looking through the blinds and in order to amuse his fellow coworkers. How is any of that within the course of his employment, which is another jurisdictional requirement that is necessary in order to waive sovereign immunity? I mean, engaging in horseplay, what does that have to do with the defendant's job as a postal employee?
Yes, Your Honor. He was working during the course of his during the course of his actions. He was logged in, checked in, and his other coworkers were involved in the same action, and the manager had some knowledge of the same set of facts as well. His choices were made during the scope of it within his employment.
Because the manager had some knowledge of it, you're not saying the manager acquiesced in it or said that's what he should be doing in the scope of his employment, are you?
No, Your Honor. No, Your Honor.
To go back to Judge Diaz's question, how is horseplay within the scope of his employment as a custodian at the post office?
Yes, Your Honor. It is in much the same way that someone performing a negligent act while driving on behalf of their employer or failing to take appropriate cautions while doing some other action on behalf of their employer, they did so or failed to do so volitionally, but they're still acting within the scope of their employment, at least in respect to the case law relative to responding as superior. With respect. With respect to the question, the ultimate question in this case, the claim is that the actions complained of arise from an assault or a battery. Essentially, we're talking about a battery here. The claim is that the sound of the airwaves making contact or striking Mr. Billups constitutes a battery under Virginia law. Unfortunately, for the United States in this regard, there's no authority rendering sound waves functional as the medium for a battery. There isn't any case law in Virginia. Virginia has not addressed it.
So what about the Adams case in Virginia that says that lasers in a victim's eyes are sufficient, that contact by an intangible substance can constitute a battery?
Yes,
Why
Your Honor.
isn't that the same thing here? Just because Virginia hasn't specifically reached sound waves as an intangible substance, they have concluded that intangible substances can constitute battery. So why doesn't that cause you problems here?
Yes, Your Honor. Well, Your Honor is right to point it out as something that would tend to, in some regard, tend to permit such a conclusion. But the Adams case is significantly distinguishable. Your Honor, Judge Thacker, you are right to point out that it involves lasers, which are actually photons, right, being processed through a specific and focused medium. Lasers are significantly less common than loud noise.
Okay. Are sound waves an intangible substance?
Sound waves, as I understand it, are molecules of air that are vibrating.
Is that an intangible substance?
Well, no court has said as much, Your Honor. No court has said as much.
Let Judge Harris.
Is it your understanding that your claim doesn't sort of sound in battery, and that's the standard we've applied? Does it sound in battery unless you 100% can win your claim as a battery claim?
Thank you, Your Honor, and I appreciate the question. And no, actually, what we're saying is that it's not a battery claim. We feel we can win as it is an act of negligence on the part of the.
Okay, that actually wasn't my question. My question is, do you think that a claim is not covered under this exception for battery unless it is a 100% sure thing you're going to win this case as a battery claim? Like, I guess what I'm saying is this sure sounds like a battery claim, and whether the government can go into Virginia court and argue successfully that Adams is distinguishable or not doesn't really much affect my thinking about that, because it's a claim that your client's bodily integrity was intentionally violated when it came into contact with some substance, whatever we're going to call it. And that sounds like a battery claim. I don't know 100% that you're going to win in Virginia court, although it looks to me like you might. But I don't think that's the question. It's just enough that the gravamen of the complaint sounds in battery. Why is that wrong?
Thank you, Your Honor. And the reason that it's wrong is because it has not been defined as such in Virginia law. If this court were to support the idea that airwaves constitute a battery claim, that would be new law created in Virginia that has not been through the process of jurisdictional review and consideration by the state courts. It's a novel idea. There are many questions that would be associated with the claim that a loud noise itself can constitute a battery. It may or it may not, but at the end of the day, but other courts haven't taken that position yet. And there are specific, and I'm not going to, the court's aware of the public policy reasons and considerations behind making this a potential battery claim. So if if Dr. Billups' claim is excluded here because it might be or it could be construed as a claim that doesn't actually exist in the Commonwealth yet, then that is a premature decision. It is the federal court making new law.
Well, counsel, actually, counsel, let me we have case law saying this isn't a state law question, that when we look at the 2680H exceptions, that's a question of federal law, and we should be looking at federal common law and sources like the restatement. So would that make you more comfortable if we say that as a matter of federal law, this pretty much looks like a battery claim to us?
Judge, the question as to whether it's well, the first question that I would have is, I'm not aware of the support for making the claim that airwaves, sound waves can be battery, either significantly in I haven't seen it in federal court or in state court. So it is a novel point to be made at any grounds. I would also suggest that if this court finds that conclusion to be accurate and that this looks like a battery claim or enough to base the dismissal of a claim for negligence on it, then the effect of that is to expand the law, expand it towards, and it will be effectively in state law as well.
Mrs. Spinelli, can I take you back to this course of employment exception? And I recognize that wasn't a focus of the briefs, but it is a jurisdictional question, and it seems to me that if this falls outside of the course of employment, battery or not, negligence or not, it really doesn't matter. And I'm still having trouble trying to figure out how these events, as you have described them, fall within the course of employment. I'm going to read you something from a Virginia Supreme Court case, and I know it's not fair that because you may not have it in front of you, but here is how the Virginia Supreme Court would define something that falls within the course of employment. First, it has to be something that fairly and naturally is incident to the business of the employer. So I don't see how engaging in a prank, as described here, is at all incident to the work of the United States Postal Service. And second, it has to, whatever the act is, has to be done while the servant was engaged upon the master's business. I suppose you can make an argument about that, but it also has to be done with a view to further the master's interests. Or an attempt to perform the master's business. And again, engaging in this kind of a horseplay activities just doesn't seem to me at all to be consistent with the work of the Postal Service. And then the last element is that it can't arise wholly from some external, independent, and personal motive on the part of the servant to do the act upon his own account. It seems to me that that's exactly what happened here. I mean, this has nothing at all to do with the mission of the United States Postal Service or the specific work that the servant, in this case, the employee, Mr. Kane, should have been engaged in as a custodian of the Postal Service. So it just seems pretty clear to me that this case falls within the government's sovereign immunity.
Well, Judge, I appreciate the position that you've taken, that you appear to take.
Well, I just want to hear from you. And again, I recognize that this was not a focus of the briefs, but I sure like your take on it.
Sure, I understand, Your Honor. I think the critical issue there is whether, if this were in a civil context, right, a different civil context with a defendant in state court, I don't think there would be an issue that the employer is responsible as much as is the employee himself. Dr. Billups was going to the post office to conduct his business. While he was doing that,
let me stop you. Why do you think there's a difference? What do you think makes the difference?
Specifically, the difference is, it all points the United States Postal Service. It's not been alleged that he was acting outside of that scope. It's not been alleged that he was doing anything other than. It's not been alleged that he was not in his office or that he was not otherwise engaged in the status of his employment there. And it just comes down to a matter of respondeat superior here.
Okay. All right. Thank you, Mr. Spinelli.
Yes, sir.
You've got some time.
Good afternoon, Your Honor.
Mr. Lucia, you're back for more. I thought we had finished with you, but
yes, Your Honor.
Go ahead.
It's been a pleasure. My name is John Lucia, and
really?
It has been, yes, thank you. And I represent the appellee of the United States in this matter. As Your Honor's noted, this, if you read the complaint, this case sounds like a battery. And the reason that it sounds like a battery is...
Why didn't you rest on this issue of the course of employment? Am I missing something there? Or?
You're not, Your Honor, and of course the court can affirm a predecessor step to, even if waived, is there another reason that the court would lack jurisdiction? So the threshold question was, can the U.S. be sued for this at all? And so that's why we addressed this one, and also because. Yes, Judge.
I'm sorry, but you argued on contributory negligence, right, in the district court.
That's correct, and the district court.
So I also was curious, like, why not this? Like, this seems like I don't want to tell you how to argue your cases, but this seems like maybe a stronger argument than contributory negligence, and they both come well after the threshold question of, contributory negligence comes way after the threshold question of has there been a waiver.
That's correct, Your Honor. We did make that argument, and listening to the court today, we should have made the other one too, but we did not. And the reason that we did not is because, again, we thought that the sovereign immunity waiver threshold question was dispositive in this case, and that's because, as the court has pointed out this afternoon, that if a complaint pleads in substance, in reality, a claim that arises out of a bad. One thing I do want to note is that this case is not expanding law, whether on the federal side or the Virginia side, and that's true because federal question is not, has a plaintiff successfully pleaded a case to one of negligence. So the court would not be saying that there is a cause of action under these circumstances in Virginia for battery, just has not waived sovereign immunity side of things, as opposed to the yes, the U.S. has. Another item I want to point out is the argument that the United States is making, and were the court to agree with it, the effect of the court's decision on that argument would not be that a claim falls within the intentional tort exception 2680H simply because there has been volitional conduct. It's because here there's been volitional conduct that was intended to violate the bodily integrity, the physical integrity of a plaintiff. And so it's both of those things. So it's not merely that someone did something intentionally, it's that the person did something intentionally, so that someone, in this case, would hear the horn, or that someone would be touched by, would be contacted by the intentional act. So again, this would not be expanding the scope of the 2680H intentional tort exception. It's squarely within that. And that's because in substance, what Dr. Phillips has pleaded is a claim arising out of battery as opposed to one of negligence. And for those reasons, Your Honor, the court should affirm the district court.
Thank you, Mr. Lucio.
Thank you.
Mr. Spinelli, you've got some time for rebuttal. Can't hear you. We cannot hear you.
Yes, Your Honor. Thank you.
Oh, there you go. Go.
Yes. All right.
Go ahead.
Very well. May it please the court, the response of the issue that counsel for the United States has addressed points out that the issue, as they view it, is not related to the volitional nature of the act, but instead addresses the issues associated with whether or not this constitutes a battery. We do not believe it does. We think that the pleadings on the face of them and the pleadings of the initial complaint make the statement that Mr. Kane was acting at all times within the scope of his employment.
Just saying it doesn't make it so.
Your Honor is correct. Just
saying it was negligence doesn't make it negligence when the facts, as alleged, seem intentional.
Yes, Your Honor. Just saying it doesn't make it so. That's absolutely correct. What I would point to is... So
going back to the scope of his employment argument, you were saying all of this was while he was working at the Postal Service, but he defaced postal property when he cut a hole in the Venetian blinds for his prank. How's that within the scope of his employment?
It had been, and I think that it's specified in the complaint that it was subsequently repaired or the blinds.
But that wasn't the question. The question was, how is his defacing of the blinds the property of the post office so that he could carry out his prank within the scope of his employment? The fact that it was repaired probably indicates that it wasn't within the scope of his employment, because when they found out about it, it had to be repaired.
What has also been alleged is specifically that he was doing so with the awareness of at least two other postal employees, and the manager herself, the postmistress there, also was involved with that, at least at some point in the process. So the fact of the matter is, based on the pleadings themselves that we have, at least at this point, the allegation is such that on its face, and viewed in the light most favorable to the plaintiff.
The Federal Tort Claims Act is supposed to be strictly construed, with any ambiguities going to the sovereign. So what about that?
Yes, Your Honor. I would say that's at a different step or a different category of review. I would
okay.
So based on that, in any event, if the court does not permit this case to move forward, the net effect for the plaintiff here, Dr. Billups, is he's effectively out of any recovery. He's not afforded any opportunity for redress effectively through this, because the lower court has determined that it's barred. And another problem or issue that
why couldn't you bring it in state court under the Adams? I'm sorry. Go ahead.
Right. When I bring it under state court under Adams, well, Adams, of course, is a criminal case, and the issue with Adams, it does not afford a new cause of action for battery. We would be pursuing a claim we would be attempting to pursue a claim under a negligence action, but we would run into the same issues on the counter side. That is to say, if he's during the scope of his employment as alleged, if he's doing the things as part of his work, he's tending to customers at the time, there's a good chance that he's going to be considered acting within the scope of his employment for purposes of this particular action, which evidently
he was tending to customers at the time. Is that in the complaint?
That is not, Your Honor, but he was active while he was
he was being paid.
He was on duty. Yes, Your Honor. Yes, Your Honor. But more than that,
are you saying you don't have a remedy against the individual employee? Is that what you're saying?
Well, it certainly wouldn't be one in battery, and there's no prejudice against any future position, but there's no recognized cause of action for that under battery. So we would be effectively. No,
the Adams case says intangible substances can constitute a battery in Virginia.
May I respond?
Certainly. Yes. Go ahead.
Thank you. The Adams case suggests that certain substances can do that, but it's not clear, and it never expands over into the idea that sound waves. In fact, the Judge Lemon's dissent in that case specifically advised against rendering expanding claims to include noise and volume for purposes of battery. So, based on all of that, Your Honor, I would ask for the relief.
All right. Thank you, Mrs. Spinelli. On behalf of the court, again, I want to thank you both for your arguments here this afternoon. We very much appreciate that. And of course, we can't come down and greet you personally, but know that you leave here with our thanks and gratitude, and be well and stay safe. And with that, the court will stand adjourned until tomorrow morning. Madam Clerk, if you would adjourn court.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.